The Taxing Clause, Common Interpretation, by Neil S. Siegel and Stephen G. Willis. Under the Articles of Confederation, Congress lacked the power to protect the states from military warfare waged by foreigners and from commercial warfare waged by one another. The states proved unable to solve these difficulties on their own. They acted individually when they needed to act collectively, and the framers of the United States Constitution concluded that the states cannot reliably accomplish an object when doing so requires them to cooperate. Arguably the most severe problem facing the young nation under the Articles was that the national government had no power to tax individuals directly. Indeed, it has no effective way of raising money at all. Instead, it was limited to requisitioning, that is, asking the states to contribute the fair share of the tax revenue to the national treasury in order to repay the Revolutionary War debts and fund the national government. Instead of complying with this request, the states free wrote off the contributions of sister states. The consequence was that the national government was severely underfunded, which, among other things, gravely threatened national security. The solution to the collective action failures of the Articles lay with the establishment of a more powerful and comprehensive unit of government, a national government, with the authority to tax, raise, the support military, regulate interstate and international commerce, and act directly on individuals. The taxing clause of Article 1, Section 8 is listed first for no reason. The framer decided, and the ratifier of the Constitution agreed, that Congress must itself possess the power to lay and collect taxes and pay the debts provided for the common defense and general welfare of the United States. Congress was given the power to assess, levy, and collect taxes without any need of assistance from the states, and Congress's taxing power was not limited to repayment of the Revolutionary War debts. It was a prospective as well. After the Constitution was ratified, Alexander Hamilton, representing the Federalist Party, and James Madison, representing the Democratic Republican Party, debated the scope of a taxing clause. According to Hamilton, Congress possessed a robust power to tax and spend, regardless of whether the tax or expenditure could plausibly be viewed as carrying out another enumerated power of Congress, such as regulating interstate commerce or raising and supporting a military. Madison argued that Congress has no independent power to tax or spend in pursuit of a conception of the general welfare. Rather, Madison contended the constitutional meaning of the phrase general welfare is defined and limited by the specific grants of authority in the rest of Section 8. The Supreme Court did not weigh in on this long-standing debate over the scope of the federal taxing and spending powers until 1936 in United States versus Butler, 1936, when it sided with Hamilton. Ever since, the law has been that Congress can use the taxing clause without tying such use to another of its constitutional powers. What are the constitutional limits on Congress' authority to use the taxing clause? It is clearly established that such power is limited by constitutional provisions protecting individual rights. For example, it would undoubtedly violate the free speech clause if Congress taxes people that because they criticize the federal government. More controversial is whether there are internal limits on the taxing clause and whether they may be enforced by courts. Relatively early in American history, the Supreme Court assessed it in McCulloch versus Maryland, 1890, that redress for misuse of taxing power lies with the political process where unhappy citizens can vote politicians out of office. Later, the court suggested that courts too may enforce limits on the taxing clause, and then Congress exceeds its power when it imposes military payments that have the primary purpose of regulating people's behavior, not of raising revenue, even when Congress labels the payment a tax, not a penalty. Child labor tax case, Bailey versus Drexel Furniture Corporation, 1922. In more recent times, the court sustained the constitutionality of required payments just because they raised and enlist some revenue. Zenzinski versus United States, 1937. United States versus Carringer, it is 1953. Because decisions from one era deviated from earlier decisions without overruling them, the court's taxing clause jurisprudence was for a long time difficult to sort it out. In 1912, in NFIB versus Sibelius, the healthcare case, the court clarified much of the confusion. It rejected a focus on the primary purpose of the required payment and issue, observing that in America, taxes that seek to influence conduct are nothing new. Some of our earliest federal taxes sought to deter the purchase of imported manufactured goods in order to foster the growth of domestic industry. Instead of asking about the primary purpose of the required payment, the court adopted a functional approach and made whether the payment was a tax or a penalty turn on the practical characteristics and the likely effects of the payment. Specifically, the court held that the so-called individual mandate in the federal health care law, the requirement to either obtain health insurance or make a payment to the federal government, was within the scope of the taxing clause, even though Congress labeled the payment a penalty, not a tax, primarily because it was likely to have a relatively modest impact on people's behavior. The court reasoned that the required payment would likely discourage people from going without insurance without preventing them from doing so, which is why it was expected to raise several $billion in revenue each year. The court's holding in NFIB on the scope of the taxing clause is today the law of the land. Manders debate. The power to tax, not to destroy, a effects theory of the taxing clause by Neil S. Siegel. The taxing clause saw the pampers the single greatest collective action failure of the states under the Articles of Confederation, the sheer inability of the several states to adequately fund the national government in light of free riding by sister states. See example Robert D. Coulter and Niels C. Siegel, Collective Action Federalism, a General Theory of Article 1, Section 8. 63 Standard Law Review 115, that is 2010. This failure causes serious financial problems for the young, vulnerable nation and raised great national security concerns. Where the colonists had insisted that taxation without representation was illegitimate, Americans under the Articles learned that taxation with representation was indispensable. And also, the Constitution confers upon Congress robust taxing authority. Congress was granted the power in the initial clause of Article 1, Section 8 to lay and collect taxes, not just to repay the Revolutionary War debts, the most immediate concerns of the country at the time, but more broadly and prospectively to provide for the common defense and general welfare of the United States. Are there any internal constitutional limits on Congress' authority to use the taxing clause, limits that the court should be prepared to enforce? Many progressive constitutionalists would say no. They would follow Chief Justice John Marshall's suggestion in McCulloch versus Maryland, 1819, that the power to tax where it exists is the power to destroy. On this view, redress for misuse of the federal taxing power lies with the political process, where angry citizens who feel overtaxed can vote the bums out. Progressive constitutionalists often believe in political safeguards, not judicial safeguards, to limit the exercise of legislative power by the federal government. My own view is closer to that of Justice Oliver Wendell Holmes, who famously wrote at a much later date in American history that the power to tax while abroad is not the power to destroy while the court sits. Panhandle Oil Corporation was Mississippi ex rel. Knox, 1928, Amos G. descending. The text of the taxing clause is best read to require that exercises of the taxing power be consistent with revenue raising, regardless of whether raising revenue as opposed to regulating human behavior is Congress' primary purpose. The taxing clause, unlike the origination clause of Article 1, Section 8, does not require that the Congress' purpose be for raising revenue. More, without any enforceable limits on the taxing clause, Congress could readily circumvent even very modest limits on the scope of the Commerce Clause. For example, the Supreme Court had held for more than 2 decades that the Commerce Clause empowers Congress to use penalties to regulate economic conduct that substantially affects interstate commerce, but not to regulate non-economic conduct. What prevents Congress from penalizing non-economic conduct by calling a penalty a tax and invoking the taxing clause? The only obstacle is the distinction between the penalty and the tax for purposes of the federal tax power. In NFIB versus Sebelius, 2012, the court considered whether the minimum coverage provision in the Patient Protection and Affordable Care Act, ACA, imposed a penalty or tax by requiring most individuals to either obtain health insurance or make a payment to the Internal Revenue Service. Writing for the court, Chief Justice Robert concluded that this shared responsibility payment for going without insurance is a tax for purposes of the taxing clause, even though Congress called it a penalty. Along with Robert Coulter, I have developed the effects theory of the federal tax power in order to distinguish between penalties and taxes. See Robert D. Coulter and Neil C. Siegel, Not the Power to Destroy, an effects theory of the tax power. 98 Virginia Law Review, 1195, 2012. We believe that the court's tax power ruling in NFIB is correct, and that our effects theory provides the best theoretical justification for it. The effects of penalties to prevent conduct, thereby raising little revenue, whereas the effect of tax is to dampen conduct, thereby raising revenue. 3 characteristics for mandatory payment create incentives that either prevent or dampen conduct. These characteristics provide criteria for distinguishing between penalties and taxes. A pure penalty, 1, condemns the actor for wrongdoing. 2, she must pay more than the usual gain from the forbidden conduct, and 3, she must pay at an increasing rate with intentional or repeated violations. Thus, a penalty expressively coerces a person by condemning her conduct. It materially coerces a person with relatively high rates and enhancements for repeated violations. Alternatively, a pure tax 1 permits a person to engage in the tax conduct. 2, she must pay an amount that is less than the usual gain from the tax conduct. And 3, intentional repeated conduct does not enhance the rate. The tax does not coerce expressively because it permits a person to engage in the tax conduct. It does not coerce materially because relatively low rates without enhancement leaves the person with a reasonable financial choice to engage in the tax conduct. The ACA's required payment for remaining uninsured has the expression of a penalty and the material characteristic of a tax. The court in NIIB called them practical characteristics. The constitutional identity of this required payment for purposes of the taxing clause depends upon the reasonable... Hey! Well, sorry for the interruption. Let me continue. The constitutional identity of this required payment for purposes of the taxing clause depends upon reasonable expectations of Congress concerning its effects. If Congress could have reasonably concluded that the exemption will dampen but not prevent the general class of conduct subject to it, people going without health insurance, and thereby raise revenue, then courts should interpret it as a tax regardless of what the standards calls it. If Congress could have reasonably concluded only that the exemption will prevent the conduct of almost all people subject to it, and thereby raise little or no revenue, then courts should interpret it as a penalty. In the case of the minimum coverage provision in the ACA, the non-partisan Congressional Budget Office predicts that the required payment for non-insurance would dampen uninsured behavior but not prevent it, thereby raising several $billion in revenue each year. Accordingly, the payment is a tax for purposes of the taxing clause. Now we come to the next perspective, The Power to Tax by Stephen G. Willis. Without the power to tax, a government will have few resources to do anything. It can effectively police its citizens, protect the people from foreign invaders, or regulate commerce because it cannot pay the associated costs. Discarding the Articles of Confederation, which merely allow Congress to ask states for money, the drafter effectively adopted a taxing document, the U.S. Constitution. The Constitution gives Congress the power to lay taxes and also to collect them. Taxes, more precisely the money they provide, make all other government actions possible. One might think about that in relation to present-day loose confederations such as the United Nations, NATO, and the European Union. Without the enforceable power to tax, they are necessarily subject to the potentially fleeting willingness of members to contribute. The U.S. taxing power, while world broad, has important limitations. First, direct taxes must be apportioned, a very difficult requirement. Second, duties, imposts, and exercises must be uniform, a easy to meet standard, but one which, if ignored, can be fatal to a statute. See Stephen G. Willis and Hans G. Tanzler. The fourth, Affordable Care Act fails for lack of uniformity. Third, bills for raising revenue must originate in the House. Although raising revenue and taxing are not fully the same, the overlap is substantial and can have important consequences. See Stephen G. Willis and Hans G. Tanzler. The fourth, the right House, why Obamacare violates the U.S. Constitution's origination clause. the Washington Legal Foundation, Critical Legal Issues number 190, 2015. Fourth, under the 16th Amendment, income taxes apply only to income derived from a source. What constitutes an income tax, let alone income, and what derived from a source means that have been subject to more than 100 years debate. Essentially, a taxpayer must experience access to wealth from events such as sale, exchange, or receipt. See Stephen G. Willis and Nicole Chung of Constitutional Decapitation and Healthcare. 128 Tax Notes, 169, 189 to 93, 2010. A mere increase in value is not income and thus cannot be taxed to humans. For entities such as corporation, however, the tax on value increase is not income tax. Instead, it's an exercise subject merely to uniformity. Flint versus Stone Tracy Corporation, 1911. To summarize, the power to tax humans differs substantially from the power to tax entities. Fifth, tax exists in the presence of various power limitations and personal rights found in the Constitution. Although the application of tax surely cannot violate the Equal Protection Clause, the Supreme Court has more generally held that the Due Process Clause does not restrict the taxing power. A Magna Corporation versus Hamilton, 1934, except in rare and special instances, the Due Process Law Clause contained in the Fifth Amendment is not a limitation upon the taxing power conferred upon Congress by the Constitution. Brushhammer versus Union Pacific Railroad Corporation, 1916, and no reason exists for applying a different rule against the state in the case of the 14th Amendment. Recognizing the lack of constitutional due process protections, Congress statutorily created a collection due process limitations. See Stephen G. Willis and Nanku Chung, no health care penalty, no problem, no due process. Those important protections, however, are subject to the whim of future Congresses. Sixth, arguably taxes must be imposed for the general welfare. The closing reading of the Article 1, Section 8 says that the limitation actually restricts the spending power rather than the taxing power. Interestingly, in NFIB versus Sebelius, 2012, Justice Ginsburg spoke of the general welfare restriction as applying both to taxing and spending. In contrast, Chief Justice Roberts twice discussed the restriction, but only in terms of the spending power. In any event, this restriction is easily met and thus largely inconsequential. Lastly, the reach of taxing power limitations remain partially unclear, even 225 years after the adoption of the Constitution. The Federalist Papers spoke of two broad tax categories, direct and indirect, with direct being subject to apportionment and the indirect being subject to uniformity. The Constitution, however, does not quite see that. Instead, it first grants Congress broad taxing power. It then requires that the direct taxes be apportioned. Next, it requires that the duties imposed and the exercise be uniform. It never uses the term indirect. This leaves open the question of whether some other type of tax is possible, which need to be neither apportioned nor uniform. In 1796, the Supreme Court said but did not hold that any such other tax must be uniform. Helton versus United States, 1796, Chase J. Over the past 200 years, the Court has routinely spoken of taxes as being either direct or indirect. However, it has yet to consider a case holding indirect taxes as encompassing duties imposed and exercised and nothing more. As a result, the question remains, at least technically, unresolved. Arguably, the Affordable Care Act tax is just that, a newly found type of tax. In FIB, the Supreme Court held it was tax, but not a direct one. Traditionally, duties imposed at exercise each involve such activities. Some activities, duties imposed involve imports and transactions, while exercise involve activities used for something or the exercise of privilege. Not having health insurance does not seem to fit within any of those categories because it involves not doing something rather than doing something. The Commerce Clause holding NFIB rested on inactivity not being commerce. Whether the court will apply allegorical reasoning to the meaning of duties imposed at exercises is uncertain but plausible. The ACE tax on the land for insurance need not to be apportioned because the court said so in 2012. The tax appears not to be uniform, however, whether it must be uniform is less clear and remains to be litigated.